Okay, we'll get started. Thank you for joining us. We'd like to welcome Justices Charlie Wiggins and Mary Yu from the Washington State Supreme Court. And just so you know, we are videotaping this. We post all of our meetings on our website for the benefit of our readers. But aside from that, this should be informal. I appreciate you coming in, and obviously a lot of issues to discuss regarding the court recently. But to start with, so why don't you just introduce yourselves and tell us what brings you to Clark County today, and then we can get into some specific issues after that. So,
Certainly.
like to start?
Would you like to go ahead?
I'm fine with starting. Thanks,
Okay.
Charlie.
Sure.
So I'm Mary Yu. I am the newest justice on the court, and I have to admit that I got roped into this CLE by Justice Wiggins, and
And what is that?
A continuing legal education seminar
Got it.
for lawyers. I'm sorry. And a former clerk of his wanted to put together a seminar on appellate practice, and given that I was a trial court judge for 14 years before coming up to the court, they thought a nice combination might be a perspective from the trial court and then obviously appellate practice.
And where is that taking place?
It's taking place, I believe, at the Red Lion.
Oh, okay.
Maybe one of the last people at the Red Lion.
It's true.
They're ripping it down.
Is that right?
Next month?
Yeah.
At the end of next month?
So enjoy it while you can.
So that's what brings us.
Okay,
here.
great. Well, thank you for taking the time to stop by and see us. Then if you don't mind, we'll get into some specific questions. I'd like to start with, very recently, the court ruled on charter schools and ruled that the initiative passed by voters was unconstitutional in Washington. And can you briefly, in layman's terms, kind of explain that ruling and where the state can go from here regarding charter schools?
Certainly.
Sure.
I'll start. The framers of the Constitution back in 1889, the framers of the Washington Constitution, were quite concerned about money, the resources of the state being diverted to private use, and so they put a number of protections into the Constitution to protect the public fisc, essentially. And one of those had to do with education and with the Common School Fund. The state was actually given a great deal of real property as part of statehood by the federal government. Given a lot of federal land, and that all went into basically supporting the schools. And over the years, a lot of that property has been logged, but some of it's been sold, and so there remains a state fund for education. And that money can only be used for the support of the common schools, which is an old term that is in the Constitution and really refers, our court 100 years ago said, well, what that really means is a school that's open to all, to children, that is paid for at public expense, and is operated by under the supervision of a locally elected board. And what happened with the charter schools case is the drafters of the initiative felt that the charter schools would qualify as common schools. And so they had the common schools, they didn't really provide anything other than all the money that goes to education, which includes both this common school fund, taxes for the schools, and a majority of the money actually is from the sales tax. It's just the general revenue from the sales tax. And so that all gets poured into the general fund and then is doled out to all the purposes that the general fund is dedicated to, including the schools. The problem with that is that basically the charter school model says, well, if a child in this state, if the school for a child is getting $10,500 for education, I'm just using that as an example, and they move to a charter school, well, that $10,500 follows them. The problem with that is it's imposed in part from the common school fund money, and that's a violation of the Constitution.
Now,
That's what we found.
It seems as though the charter schools where they don't meet the common school definition is that their board is not elected. Is that accurate?
I think that's the key,
Okay.
a key distinction, yes.
And actually, before we go further, I'm curious, how did the two of you vote on that?
In the majority.
Okay,
Right.
and I believe it was a 6-3
It
decision.
was a 6-3 decision. The majority was written by our Chief Justice, Barbara Madsen,
Right.
and the dissent by Justice Mary Yu.
Now, why is it that I believe 41, 42 schools, or states in the union can have charter schools, and we are unable to under this definition?
You know, I can't answer the question in a way that it ought to be answered in the sense of, I do not know what the other states actually say in terms of their constitution. And I really think it has to be looked at under each particular state law.
Sure.
So I really couldn't comment to say, why do they get to have it
Right.
and we don't? You know, because our analysis was very specific in terms of what does our state constitution say, what does even frankly our case law say in terms of how we understand what a common school is. So it's really tough to be compared with
Right,
other
and I
states.
can understand that. In this regard, if charter schools here did somehow have elected boards, would that be enough to meet the definition?
Well, that's an issue that is discussed in the opinion, and I think that's the main problem that was raised. Going back to your question, I'm not sure it's fair to say that we can't have charter schools. I think that they could be structured. It probably could be structured. I can't really speak to that, and don't want to speculate on what might be done. But the problem certainly can be tackled, and it's entirely possible a constitutional solution could be found.
And that, I'm sorry, just
No,
saying,
no.
that brings up the next question. You don't want to speculate. We've often gotten into a situation in the state where the voters pass initiatives and then the court overturns them. Should the courts review initiatives beforehand? They've always been loath to do so. Wouldn't that save us a lot of trouble?
Well, it sounds easy, but I think probably, we do not have a history in the state where you have the Supreme Court weighing in and deciding a question like a pre-election initiative issue before it even goes on the ballot. We just haven't done it. I think we've done it once. It's not something that is done as a matter of routine. Any lawyer might also sit down, take a look at something, and opine as to whether or not something would really reach, or pass a constitutional muster in that sense. So it's, is it possible that that could happen? Sure it would. Could it happen in 24 hours, in 10 hours, in 2 before it has to go on a ballot? I doubt it really, in terms of really having an opportunity to meaningfully look at an initiative and render an opinion as to whether or not it's constitutional.
In that regard, do any other states do that? Do they review initiatives or laws before they are enacted?
I think it's rare. One example would be Massachusetts, which has a procedure under which their Supreme Judicial Court can review a bill that is referred by the legislature and opine on the constitutionality of it. I was thinking about this as we drove down this morning. It's what we call a case or controversy requirement. There has to be a real live case in front of us. And if it hasn't been passed, there really is no real live case in front of us. And the United States Constitution is interpreted to not allow courts to opine without a case or controversy, and we've kind of followed that lead, even though our Constitution's worded a little differently.
Do you feel the frustration of residents who vote for things and then get them tossed out? Some of Tim Hyman's initiatives seem to have a history, almost an expectation at this stage of getting it on the ballot, having people vote for it, and then having this real sense that there's something wrong with this system, and that can be debated, but there's something wrong with this system that residents keep voting for something and then the courts keep throwing it out. Do you feel that frustration?
Of course. I don't think that there's anybody on the court who doesn't really deeply, at a very human level, living in community with people, feel that. And understand the level of frustration that people may feel in terms of not fully understanding why it is the courts somehow, finding something unconstitutional when it was voted by the people. And I've continued to say, because I'm out there talking with people all of the time, is when something is enacted, whether it's by the legislature or by popular vote, it's going to be looked at in the same way in terms of really, is this constitutional? Does it really comport with certain principles that we have embodied in the Constitution and in our case law? So it's tough, it is. You know, I believe in the popular vote, I believe in democracy and people's right to weigh in. The unfortunate thing is, again, when we're looking at it, sad to say, it really is with blinders, is to say this doesn't get more weight because it was enacted by the people. Although I would say with a heavy heart, everybody is aware of that. I mean, everybody is aware of it. It's hard. It is.
This kind of circles back to Greg's question earlier. Should we vote on these? Should we examine the constitutionality before the vote and possibly deprive the people of the opportunity to vote on it, or should we wait? Because some initiatives fail, obviously, and so shouldn't we let the voters have their say before we weigh in on it? And that is where we've come down. The only time in which we would step in and take something off the ballot, an initiative off the ballot, as Mary referred to earlier, is when we conclude that not even the legislature couldn't pass a law like this, not because it's unconstitutional, but because it's not part of a legislative function. Mm-hmm. And so that's the distinction. And so our ruling, our recent ruling on the Iman initiative about taxes, you know, we concluded obviously that it was within the legislative power and allowed that to go down.
And I guess I would only suggest that the way in which you just framed it, you know, personally I would agree with it. I think the way most residents would look at a review would not be with an eye toward, look, they've kept something off the ballot, but an eye toward, look, they've examined this, they've shown it to be not passing muster, and then therefore you can go back and redo the initiative so that the initiative that does hit the ballot can be one that will pass muster when it's over. So I mean, that's the way that I would frame that.
Right, but you know, it's so interesting. There's some recent writings and one particular law review that is cited by a lot of people that came out of Notre Dame that really talks about the idea that could an initiative also be a First Amendment right to free speech, in the sense that perhaps individuals realize it may not pass constitutional muster, but this is a vehicle for individuals to express an opinion and send a message to their legislators or to their elected officials about how they might feel about a particular issue. We haven't addressed it, but there's enough writing on it that might say, well, maybe some people really don't care whether at the end of the day it's constitutional or not. It's a chance to express the level of frustration about a particular matter or question or taxing. But that's something also could be why people want to vote.
Yeah, sure.
And I can understand that. I think in this case, much of the frustration is that the initiative passed, they actually started to get charter schools up and running, and then the court, I believe, heard hearings last October, and then ruled right before the school year or for many kids, the school year had already started. The students were already in school, and now some of these might have to shut down. What was the reasoning behind the timing of the announcement?
At any one time, we have several dozen, more than several dozen opinions that are in circulation among the judges. And it takes time to review a case and to come up with the opinion. And even once, the interesting thing is the way we operate is we hear an oral argument, we go back and we immediately vote, and that vote determines who writes the opinion. But there are kind of shifts in votes sometimes as the opinion goes into circulation, and I'm certainly not going to comment on what happened exactly in this case, but those shifts can delay the opinion getting out. We really weren't trying the decision to issue the opinion, are you talking about on the Friday,
Yes.
September
Yeah.
4th?
Yeah, right before Labor Day.
You know, there was no intent to do anything other than get the opinion out as soon as we could. We felt it was an important enough issue at the beginning of the school year
Sure.
that we wanted to have the opinion in people's hands as soon as we could. As you know, traditionally, we issue our opinions on Thursdays, which is kind of a bit of an archaic system because it was all based on paper opinions going on, physical spindle in the clerk's office, and reporters coming to the clerk's office to look on Thursday morning and see what was there. In this day and age, we're no longer really bound by that kind of paper trail because we can do everything electronically, and that's the way you access the courts now, is electronically. So, you know, this has really opened up some discussion among the judges. Well, should we change the way we do this? It's really kind of a system that we've had in place a long time. Division 1 of the Court of Appeals issues it on Monday, Division 2 on Tuesday, Division 3 on Wednesday, and we issue on Thursday. So we weren't trying to step outside the normal boundaries other than we wanted to get it, with school starting, everywhere except Seattle. We wanted to get the opinion out as soon as we could.
You know, it's one of the things I got to tell you that as a trial court judge, I used to be very frustrated with how long it would take maybe to get a decision back, either from the Court of Appeals or the Supreme Court. And then when I got to the court and learned about the process in terms of how long it really takes, because once somebody authors a decision, right, it has to go to 9, who then may all have some comments. It goes back to the 9. And perhaps the dissent says something that they weren't going to say, and then somebody shifts.
Sure.
And it's astounding to me how long it actually takes for all of the writing to be done, for everybody to have a chance to comment, to make changes. And the case might change in the sense of suddenly the majority's been lost and now it's reassigned for some reason. But it takes time, and there's no question, because now, of course, I've heard what you've heard. I mean, there's no question that nobody put thought into, let's consciously release this on a Friday at 4 o'clock before Labor Day. It was not even thought about in a sense of, there was no deliberate intent to do that other than to go through the normal practice and say when a case is ready, it goes out. And then I think probably during the week, people thought, we ought to get this out. It ought to hurry up and get to the top of the list of the 10 that were ready. Nobody really given much thought to management of when it does get released or not, you know. And there was no deliberate intent to wait until now. What I've learned is, I guess, a slow media time or a slow news day. I mean, I'm not thinking that way. I don't think anybody at the court is thinking that. But I think we've all heard a big thud like everybody else has in terms of the timing.
And I'm curious, are there any constitutional guidelines about how long you can consider a case, or could you hear arguments and then debate and rejigger the opinion and release it 2 years after the arguments? Or is there anything, are you bound to any timetable?
We have a requirement that every time we're paid, we have to sign an affidavit that nothing has been pending on our individual desk for more than 6 months.
Huh.
And so, we watched that pretty carefully. When I was on the Court of Appeals as a partner, there was one Court of Appeals judge who was chronically late, and there were times he'd miss a paycheck, and he would get a late paycheck because he finally got his opinion. So that's kind of the outside.
That'll get your
that's the
attention.
outer limit. But the way that works is it's an individual by individual case.
Okay.
So if I were to take 3 months to write an opinion and circulate it, then the next person might take another 3 months, and
Right.
then I'm in later runs. So
Do you think that might be a good idea for the state legislature? Get your job done, or, you know, the paycheck?
I'm not going to comment on that.
Oh, we'll get to that in a
You know,
little bit, trust me.
Really, in terms of, when you really look, and again, maybe as the new kid on the block, the thoughtfulness, the work that really goes into a decision is something I just didn't really recognize until I came to the Supreme Court, in terms of how thoughtful everybody really is about commenting or making changes, while they're also writing other decisions. I mean, so there's never just one decision that's moving around. There's 30 or 40 at any given point, constantly moving, constantly being modified. And what I've been most impressed by, frankly, is the thoughtfulness behind every single sentence and thought and word. You know, so would anybody, whether it's the legislature or the public, say, oh, we want this on a timeline and you got to do this, and so forget every other case because this one's more important than all the others? But, you know, somebody sitting in prison waiting for their case also in their opinion, you know, that's pretty important too. And you would find it terrible for anybody to start to dictate how that has to happen. Should it be timely? Yeah, I think all of us there want to say we want to do this in a timely fashion, but not at the expense of trying to do everything we could to get it right. Really.
If I could add to that too, since I've been on the court, actually we've been pretty conscious of this, the delays in getting our opinions out, and we've been working on that. The length of time it takes us to get an opinion out from the time it's argued is coming down. And so we're tightening up there. We're trying to tighten up at every phase of the process because you don't want a case hanging around a long time. 11 months is a long time to wait for an opinion. As a lawyer, I was frustrated many times by waiting for that.
I'm sorry, I want to back up just very quickly, and then we can move on. Now, in the case of Initiative 1366, the latest Tim Eyman one, the court decided not to rule on the constitutionality of it, so it can go on the ballot. Is that accurate?
That's correct.
But that is not, you did not say that it's constitutional, if it's passed by voters, it will be enacted. You could, in theory, review it if it gets passed. Is that?
If somebody brings a case.
Right, right.
Let's
I just
say
wanted to
likely.
clarify that. Yeah. So, I'm sorry, go ahead.
When you all write opinions, how much of it is you and how much is it somebody else on the law clerk?
I don't think there's any fixed formula for that. I can tell you this, that I do rely on my law clerks. They do draft opinions. But there's not an opinion that goes out that I haven't gone through and changed a lot. Not a lot, not necessarily, but to change substantially pieces of that opinion. And it's not, that's not even the first step. The first step comes even before the oral argument. Every one of our cases is assigned to a specific judge before it's argued.
Okay.
That's done on a purely random basis. Literally, they're drawn out of the hat to do the assignments. And so the judge who's assigned to that case spends a lot of time with that case before the argument ever occurs and prepares a memorandum that goes to the other judges. And that's where there's an awful lot of work that goes on between the clerk and the judge, getting that memorandum ready, and that then becomes kind of a platform on which the opinion is written, tailored or changed, of course, depending on what happens during argument, during the conference.
Now, does that judge necessarily write one of the opinions, either the majority or the minority opinion?
Yes, if that
Okay.
judge gets a majority of the votes, that judge will write the
Oh,
majority.
okay.
And
Interesting. I
if
was
the
going to
judge
ask how
does-
they decide who writes.
Yeah, if the judge does not get a majority, the judge has an option.
Sure.
You can either say, you know what, I yield to the majority, I will write it the way the majority wants it written. I wasn't convinced of that, but I can bring myself to write it that way. Or the judge might say, and I think this is more frequent, no, I'm going to stick by my guns. I'm going to write it this as a dissent. So that's an option.
And you know, each judge has a different relationship and approach to probably how they write in that sense. I know, again, just being fairly new, I'm very controlling in the sense of doing an outline first, saying to the clerk, this is how we're going to approach this. This is how, you know, I think the law requires us to conclude this particular question. It is a lot of give and take, and I think every single chamber's is probably different. So in terms of how they begin to approach an opinion in some way. And then I think probably every single justice is probably controlling on editing and really working that to make sure that that's really a reflection not only of style in terms of that justice, but really what the court decided in terms of what was said at conference and who has the majority or the dissent, if that's, you know, how you're writing.
Yeah, I actually will tell you that I asked that question because recently here um, a mini controversy came up because of politicians and, of course, with social media. Are you guys on Facebook?
I am.
I am too.
I have a
You
public
have a
official
personal,
page, no.
Not a personal page?
It's a
An
public official page.
Okay. And when you post something on that Facebook page, do you write it?
I do it all myself because I do not want anybody else to have any opportunity for mischief.
And you say you have a Facebook page?
It's the same thing, I do it myself, and
Okay.
frankly, I'm a little sporadic.
Well, okay, you're not, yeah, okay.
I
get
post
it.
every day.
And the reason why I brought this up is because recently here, there was, again, this mini controversy where politicians, people running for office, would post something on their Facebook page, and then this question would come up as to whether or not the politician himself wrote the post, or whether he had somebody write the post. Of course, we know in the political arena, politicians from people running for president all the way down to cemetery director, maybe not that far down. You know, they have oftentimes a team of people, and it wouldn't be unusual for speeches to be written by other people. It's common practice. So this sort of blew up a little bit here recently as to whether or not a politician was writing his own stuff, whether he had somebody writing his stuff. So this sort of morphs into this idea of really everybody in public office. Now, I know my daughter is a third-year law student at the University of Georgia, and so I have some appreciation for what attorneys do and what law clerks do, and that they're there to help, and they're there to do a lot of the heavy lifting. I mean, there's no getting around that, and judges rely on law clerks. So,
But you know, the best thing about this particular court, and because I haven't sat on another Supreme Court, I really can say, is the opinions at the end of the day are the court's decisions.
yeah.
And these people that I'm sitting with, there's not going to be any one of them that's going to let you get away with a word that does not reflect the court's ultimate decision in terms of the case resolution. And that's what I love. I love that people could walk down the hall, or somebody will send you an email and say, gee, you know, might you really change this tone a little bit, or might you do this, or I love that about what we do, is that there's real ownership by everybody to say, this is the court's decision, it's not my decision,
Yeah.
it's the court's decision, and everybody feels very, very comfortable challenging the use of language or anything else, and I think that's what's so good about it. And I really want to dare to say, I bet it's unlike many other courts. The level of collegiality around this table is really very, very good, that challenge could occur without people being personally offended.
Okay. Can we talk a little bit about McCleary, because we know we love that. It's probably on your list.
Yes, but go right ahead.
So now the State Supreme Court has begun to fine the legislature. You've probably talked or heard about this hundreds of times by now since the original decision was released, so you probably can do this in your sleep. But nonetheless, $100,000 a day. I guess what, trying to play a little bit more hardball with the state legislature? That's a fair statement, right?
Well, I would say this. What do courts do when a party to the case won't do what the court tells them to do? Courts hold people in contempt. I mean, that's what you do. And that is a part of the essence of the judicial power, is to hold people in contempt. What do you do? What you do after that really depends on a great many factors. I mean, what we're talking about here is what we call a coercive contempt. We're trying to push them along the path of getting, of raising, increasing the amount of funding so that the state is complying with its paramount duty to educate the children of the state. And what are some of the ways you do that? Well, you can go all the way from sort of the top end of the range, put somebody in jail until they will comply. It's kind of hard to see how that would work in a case like this. we held the state in contempt. We didn't hold any individual legislator in contempt, we held the state in contempt. And so what other alternatives do we have? There are a number of alternatives you have for contempt, but one of the traditional ones is to fine people and to have a daily fine. So again, you're encouraging them to move in the direction of compliance. And so, I mean, that really is why. That really is, at least I speak for myself, that was my thinking on why do we go this way? Because it's something that we traditionally do, something that's certainly within the judicial power.
But how weird is it that you're fining them $100,000 a day, of which the taxpayers are gonna have to foot that bill and enter irony, and what you're asking them to do is put more taxpayer money into the school systems of the state. So this is sort of a circular money switch that's going on here. You're finding them money that they're going to have to go into the taxpayers' coffers to pay because they're not using taxpayers' money in the right way. Isn't that kind of weird?
Yes, it's a very odd situation, and in the grand scheme of things, you know, it's not an over the top sort of a fine.
No, it's not.
Because the amount of money that goes into our school system, $7 billion by any amount, it's a lot of money. I think that's a fiscal year actually, not by any. So, you know, yeah, it's a little odd that it works out that way, but that's pretty much
There it is.
that's the way you do things when you hold the state.
Did you ever?
Well, you know, I was just going to say, it's a very measured way to enforce a court order. And I keep going back to my own experience as a trial court judge. You know, we had this situation come up all of the time in child support. You know, people who didn't pay child support, and no matter how many times you may order them to do that, they don't do that. And you can finally say, well, I'm going to put you in jail. Well, really, then you take the total income away from this individual because they might lose their job, and the ability to pay at the end of the day really is what you want. And so you might find other ways to coerce somebody into doing what the court ordered them to do. And I think you've seen enough of the commentary that there's a spectrum of options the court had. And I would say really it's just a measured one that says, yeah, we're serious. You know, I wouldn't define it as sort of hardball playing with the legislature in that sense, because that almost trivializes the significance of what we're trying to do, is to enforce a court order.
Now, and critics would say, though, that in the end, it's up to the legislature to decide how to spend the state's money. Where does the court come in usurping that duty?
Well, it's their plan that they came up with, that we are simply saying, do what you said you were going to do in terms of fully funding education. It's the paramount duty of the state to do so. You fail to do so, and we're not telling you how, but do it.
But so you're not telling them how much?
There isn't an amount that they've set themselves for what it costs to fund their plan that they defined and that they put into place. They even had their numbers. The question is just get it done. I think to be able to then say, get it done, isn't somehow stepping over and saying, well, this is how you're going to do it, and this is where you're going to get the money from, and this is what you have to enact. And the court hasn't done that. It's simply saying, get this done. You laid out the plan. You know what it costs because you put the numbers together.
So if they had laid out a plan that had half as much money that this plan had, would it be possible that the Supreme Court would step in and say, no, you didn't put enough money in your plan? Because you're basically saying right now that it's their own plan that they're not following, and that's the reason why we're fining them. If they had put a plan together that was significantly less money, would you still stand on the idea that, well, okay, follow that plan and that would be okay?
The way I look at this is you start at what is required for adequately funding education. So you don't start with a bucket of money. You start with, well, we've got bus transportation. We've got materials, supplies, and operating costs. We've got teacher salaries. We've got there's another component that I'm forgetting.
Well, and I'm sorry, as Mary said, those numbers were defined by the legislature, right? It's not like the court said, well, you need 13 billion for this.
Right, but the question
Okay,
that I'm
so go
asking
ahead.
now, yeah.
Now, go ahead.
But the point is, the legislature didn't say, well, we're going to give you bus transportation half the days of the year. You know, this is
Right.
this is what it actually takes to put kids on buses, and these are the real numbers. So, you know, they're operating from, okay, this is what we think would be adequate, amply funded for education, and you know, what would it look like if they did less? I'm not sure how we would do that now, to tell you the truth.
That's what I wondered too, so that's why you know, right now, again, I think you're sort of hanging your hat on the idea that they've got this plan. Somehow or another, you sort of have approved of that plan and are saying now just implement the plan.
Let me step back, and I really should have said this too. The determination that this was adequate was not really something that was done just by us. Judge John Ehrlich in the Kent County Superior Court tried this case, and it was a 3-month trial. There were 55 witnesses called, 55 expert witnesses called. Massive amounts of information was considered, and at the end of that, he entered a very lengthy set of findings of fact. So, and while that was going on, the legislature was looking at what's happening. So these things were kind of coming together. So we had something to rely on. I mean, the superintendent of the school district out in Columbian comes in and says, you know, here are my problems, and here's the shortfalls. So there was a lot of evidence that went into this. Now, what if the legislature came back? I don't want to speculate about
Oh, please.
in a what-if scenario, but all I'm saying is there is data, there is evidence
Sure.
that was presented, and that was the original decision that we issued in January of 2012,
Right.
was upholding Judge Ehrlich's findings
Right.
of fact. Well, actually, the findings were hardly challenged.
I think this is sort of in your purview, but as we all know, in addition to the state itself funding the school systems, the various local school districts also are funding the school system. And as we also know, the original intent of those local levies were really, for lack of a better term, sort of the bells and whistles that a particular local school district would like to add to the state funding. And, as we also know, as the state didn't fulfill the obligation that some folks thought they should, these local levies became more and more of a critical need in order to complete what most people would say is the basic functions of school. So now local levies here, for example, are paying for many school teachers, many very basic things, and the levies have sort of gone up and up and up, as most taxes do. I give you all of that background, which I know you know, to say that as the state, assuming that the state goes along with the Supreme Court's ruling and begins, or actually does, accomplish its paramount duty by adequately funding the school systems in the state. By extension, logic would say this amount of money that local school districts are now paying through levies can come down as the state's obligation or meeting that obligation goes up. Is that a fair statement as a possibility?
Geez, I don't know. When we talk about speculating, I don't know. You know, we're not going to be putting our thumb on whether or not the local levy is the answer to go down or up. You know, we mentioned that in a footnote specifically, that we're not weighing in on that. I mean, that's an issue and that's been a problem. Could that happen? Yeah, that might. I mean,
You know, as you know, this whole issue with the levies was one of the big issues in the McCleary decision itself. And we didn't, our contempt order and our enforcement order really hasn't addressed that so much. I think on the theory, as you say, that if the state adequately funds education, we're not going to have a problem with local levies being used to support basic education. And those proposals are certainly before the legislature now in terms of, all right, let's do a levy swap. Let's take monies that's going into the levies and divert those back into the state and use the funds that way, so we don't get inequities arising between poor school districts and properly rich school districts. So that's a part of McCleary that we really haven't kind of focused on so much, and the plaintiffs haven't. I mean, the plaintiffs in the McCleary case have really pushed in terms of let's get the roadmap, let's get the plan, let's get things in place.
Right, I guess it is fair to say, though, that you are concentrating on the state's obligation to fulfill this paramount duty, no question about that. And when you look at the total pot of money that is going to schools, not just from the state, a reasonable person would reasonably conclude, they use that line in court a lot, a reasonable person would reasonably conclude that you should be able to reduce that amount of money. You could be able to reduce that amount of money in the local school levies, because now the state is fulfilling its obligation. Before it wasn't. Local districts stepped in to help out. Now they are. Local school districts can now step out a little bit. I mean, that's a reasonable conclusion, of which you don't want to speculate on, I get. But you're human. You could profess.
Would I personally like to pay less taxes? Yes.
Okay, there you go. I'm going to take that.
And one more question about not speculating. It's my understanding the legislature needs to approve funding for this $100,000 a day, I believe.
That's
And-
what I've read also.
Okay. Let's say they don't do that. Let's say we're tired of this roadmap, we aren't going to do anything else. Then what does the court do? If the legislature ignores...
Great question. I don't feel comfortable answering that in a sense of really, I mean, that question may actually come before us.
Sure.
And who knows, right? Who knows what's going to be in a pleading? Who knows what the state's going to argue? It really, everything's on the table in that sense. I mean, I have no idea what we might do at all.
There's one aspect I'd like to address of this as well. I think the legislators as a whole want to fix this problem. They want to adequately fund education, and there's a lot of goodwill within the legislature. So we've been kind of pushed into the corner of sort of becoming a we-they sort of proposition. But I don't see it that way. I think that we have good legislators, and we have a lot of people who, in their heart of hearts and in their pocketbooks, want to comply with the McCleary decision. And I would hope that that's going to happen. And it's not an easy thing to pull up, to find the money to adequately fund education, especially when we were coming out of a pretty deep hole economically as a society. So I still hope and hold out hope that they will find a way to do this, and that we don't want to be in the role of a combative role. We really want to be in the role of saying, we really encourage you to do this and to move this process along.
And just, I have one other quick question related to this. Do other states have a similar paramount duty clause in their constitution, be it education or fire and police? Is this unusual for Washington?
I think it's very unusual.
Okay.
I think there are states that have a paramount duty, but not very many.
Okay.
You see this type of litigation in several states, I think
Right,
New Jersey.
because it's not,
Kansas.
right, Kansas,
Right.
it's not unique to Washington, but it seems unusual.
Right.
Now, we just had the State Attorney General Bob Ferguson, in, who represents the legislature. He obviously thinks you guys are a little off base. Do you guys have an attorney representing you? Or do you just hang out and do your own thing?
Ironically, the attorney that represents us is the Attorney General.
Wait a second now.
As an
So
entity.
does he fight with himself in the bathroom?
Well, the Attorney General's office, of course, represents state agencies, and we are
Right.
another state agency, and I don't purport to know how they manage that, but, and if they end up on the opposite sides of the case, I think they bring in someone to represent, but we're not a party institutionally to
Right.
the McClary case, we're the court. So-
Right, right.
So, no, we're not adverse to the Attorney General.
But you're obviously aware that he thinks you guys are a little off base.
So I read, yes.
Okay. I mean, he hasn't knocked on your door and told you that personally? All right.
You know, I have to just say, in fairness to RNG, and I only read the newspapers as well in terms of what you may be reading or
Well, we just had
or
him in here,
anything
so he
else.
told us.
It would be unlike Ferguson to use that language
No,
to
he-
disagree.
He didn't use that language.
Yeah.
But he does disagree with some
Which
of the
is-
rulings.
Really, that's what we live and die for as lawyers, right? Is we disagree, we see things from different perspectives, and he has to represent his clients in a zealous fashion and really take positions that might be in disagreement with the court, which is different than saying we're off base, because reasonable minds can really differ on how you look at this.
All right, I will disagree with you on that. You just defined what off base is. If you look that up in the dictionary, but
Have your daughter work on you with that.
So, should Supreme Court justices, should they be elected by district?
I think that we should be elected statewide. I have that belief, and the reason is, our jurisdiction is over the entire state.
But then don't they all end up coming from the same area for the most part?
Well,
I don't think so.
Don't
I
think
know
so.
I hear that all the time, and there's two of us from King County.
Oh, okay.
You know, I know there's a perception that everybody's from King County, but that's not true. And at the end of the day, I'm living now most of my time in Olympia.
Mhm.
So I'm in Thurston County more than I'm in King County. But there's only two people who came from King County, myself and Justice Gonzalez.
and of course, Justice Stevens is from eastern Washington.
Right.
She lives in
Right.
Thurston County now. But
Right.
there's two of us from Kitsap County,
Okay.
two, I think, from Pierce County, and Justice Owens, of course, is from Clallam County. So there's...
have you ever had one from Clark County? Well, do a little research on that.
You should run.
No,
I know I was the second from Kitsap County, that's all I know.
Okay.
But you know, and really, I have to say, I love that I am now really looking at the state in terms of really trying to get around to meet people and go all over the state. Would it be easier for me to run in one district? Oh my gosh, yeah. In terms of geographically, it's really hard to get around the state. I've run in King County, I've been from King County. That would be really easy to be from, you know, that little slim corridor, and that would be really easy, and I'd love it. Is that the right thing to do for a state Supreme Court justice? I don't think so. I think it really ought to be a statewide office. And I can tell you, in the year that I have been on the court, and the amount of travel around the state has been really, really wonderful in terms of meeting people, hearing their concerns. We just came back from Forks. I would never go to Forks for any other reason. I mean, I just haven't read the novels involving a vampire or werewolf. You know, I mean, so there wouldn't be a reason to go to Forks. And wow, it was incredibly wonderful in terms of hearing from people and meeting them and meeting kids who might not ever leave Forks, frankly, and just having the conversation was very good and really important for a state office. So at one level, yeah, it would be really easy for me to run in my district, but I don't know.
You know, and unlike a legislator, we don't represent people in the sense a legislator does. I mean, we're, So it's a real different dynamic
Sure.
that goes into our actions.
Thanks. Great, well, thank you. Anything?
I have one final question. Have you seen the movie My Cousin Vinny, and what do you think about it?
I love that movie. I love that movie. In fact, my wife and I recently watched it again within the last month and just howled with laughter at it. I mean, we knew everything that was coming and we knew all the jokes, but we enjoyed it.
I love the movie. I use it all the time to teach.
Oh, do you
And
really?
believe it or not, I used to teach contempt at Judicial College for judges, and so that was my favorite clip. That and Three Stooges, right? You know, do you swear to tell the truth, the whole truth, nothing but the truth? I mean, I love it.
Oh, yeah.
Yeah, great movie.
Yeah, I particularly like the Utes.
Yeah,
line.
yeah.
Utes? Utes! Anyway, thank you very much.
Well, thank you very
You.
much.
Thank
Absolutely.
you.
Our pleasure.
So you gotta come to my Facebook page.
I'm going to.
So I love your socks, which so match your tie.
Do you see that tie?
Yes.
I've got to get my glasses to see
Now,
what it is.
between your tie and his bow tie, I'm gonna have to take a picture. Is that all right? Can
Oh,
we do that?
Florida.